Next case will be People versus Hewitt-El. Do you want to pull that down a little bit?
Okay. Okay, good morning, Your Honors. Shari Grove from the State Appellate Defender Office on behalf of Jonathan Hewitt-El. I would like to reserve about 3 minutes for rebuttal, if I could. This is the somewhat rare case where the trial judge granted a motion for relief from judgment. The Court of Appeals reversed, and on defendant's appeal, this court has ordered briefing on 3 issues, supplemental issues. First, the prosecutor concedes for the most part that the grounds for relief were not decided against Mr. Hewitt in the direct appeal. And I would submit that the Court of Appeals' opinion that certain issues were decided against Mr. Hewitt is clearly erroneous. As for the remaining issues, the trial judge, who, as you know, presided at both the trial and the evidentiary hearing, concluded that trial counsel failed to protect Mr. Hewitt's substantial constitutional rights in several ways. On appeal, the Court of Appeals undertook its own independent review of the facts. The court concluded that some of trial counsel's failures could be attributed to trial strategy, but this finding was based on the Court of Appeals' independent credibility determinations. But the court further decided that even if trial counsel were ineffective, the alibi was not credible. This finding is based on some minor discrepancies in the timeline and some minor inconsistencies in the witness's testimony. But more importantly, in making this determination, the trial judge erroneously usurped the role of both the trial judge and the jury. Our Constitution leaves it to the jury and not the courts to evaluate witness credibility in deciding the guilt or innocence of a defendant. So if the alibi were believed by the jury, Mr. Hewitt-El would be found not guilty, and he is entitled to have a jury make that determination. With regard to the medical witnesses, the trial judge found their testimony was credible and would have made a difference because it corroborated an important facet of the defense. But again, the Court of Appeals ignored the trial judge's findings and substituted its own opinion. Finally, the Court of Appeals refused to address trial counsel's failure to move to suppress Mr. Hewitt's numerous prior similar assaultive convictions. The prosecutor has no real answer to this claim of error, and as the trial judge found, Mr. Hewitt was absolutely prejudiced. So individually and cumulatively, the errors of defendant's attorneys denied him his constitutional right to a substantial defense and his constitutional right to effective assistance of counsel.
Counsel, what's your best argument on prejudice? Why would a different outcome be likely if there wasn't but for the ineffective assistance of trial counsel?
Well, Mr. Hewitt went to trial without any witnesses on his behalf. He wanted alibi witnesses. He wanted his doctor, his physical therapist, to testify in support of his other defense. And he was impeached by both his own attorney and by the prosecutor with numerous prior armed robberies when he was on trial for assault with intent to commit armed robbery.
And is it your view that those armed robberies certainly would not have been admissible if trial counsel had made an appropriate motion?
Yes, definitely. There's a little bit of element of dishonesty, but they are primarily assaultive, and they were similar, if not the exact same offense, and that's one factor that weighs heavily in the prejudice analysis, and there are numerous cases finding that that does constitute prejudice.
The issue with the alibi witnesses, it's not unusual for a defendant to say, I have witnesses and alibi witnesses, and then tell their attorney not give any contact information or even provide a full name. And it seems to have happened here, and even with the girlfriend whose number he was, I guess, able to provide, when it finally came time at a Ginther hearing for her to show up and testify, she wouldn't come either. So why is it, I mean, if we agree with your argument in this case, isn't every criminal case where a defendant says, wait, I want you to call my friend, Louis, who will say that I was somewhere else, that's going to be enough? And what's defense counsel supposed to do?
Well, in this case, defense counsel did practically nothing. He talked to Sheila Jackson.
He interviewed the girlfriend, the only one whose identifying information was given, right?
Yes, he talked to her. He determined, based on an inaccurate view of the timeline, that she wouldn't be an alibi witness, but he admitted that there were other witnesses that Mr. Hewitt told him about, so we don't know whether he had the first and last name of those witnesses because he didn't even write them down. He didn't ask the son for any assistance in finding those witnesses. He left it up to the defendant and to the defendant's family to produce those witnesses. Mr. Hewitt was not representing himself. He had an attorney who was basically there by default, just waiting for the family to hire somebody else. And the fact is that Sheila Jackson called one of the alibi witnesses numerous times to find out if he'd be willing to talk to an attorney, if he would be willing to talk to the police, if he would be willing to testify on Mr. Hewitt's behalf. And the attorney never contacted Mr. McCline, and the trial judge found, and I think it's a reasonable finding, that if he had done more investigation, he would have found at least one of the alibi witnesses. And the facts at the evidentiary hearing pretty much prove that Sheila Jackson would have been an alibi witness as well. The fact that Sheila Jackson did not testify at the hearing is a problem, but by that time, as I understand it, she didn't refuse to come, but they had broken up. There was some hostility. He had lost contact with her, and for that reason, she did not testify at the hearing. But Mr. McCline testified that she did contact him, and if the trial attorney had not just left it up to the defendant to produce his witnesses, I think it's reasonable that he would have found at least one witness. And again, he didn't even write down the names of the witnesses, so we don't know who that third witness was. It wasn't Craig, because Craig was a witness for another issue. But be that as it may, the two alibi witnesses testified at the evidentiary hearing, and their credibility could have been attacked at trial, but ultimately it was up to the jury to determine whether Mr. Hewitt had an alibi. The trial judge, as I've said, made reasonable findings of fact, made reasonable conclusions of law, and the reviewing court is not entitled to reverse the trial judge simply because it would have come to a different opinion. And I think that's what happened in this case.
The trial judge is kind of the closest to this, and you indicated it's kind of unusual for the trial judge to basically grant a new trial. So maybe you could emphasize or discuss a little bit the issue of kind of the deference that should be paid to the lower courts.
Well, the deference to the lower courts for factual findings is great deference because the trial judge heard the testimony, the trial judge saw the demeanor of the witnesses, the trial judge has the expertise in evaluating credibility of the witnesses at the hearing, and ultimately witness credibility, if the testimony of the witness is reasonable, is for the jury to determine. I don't know if I've answered your question.
You did.
Did the prosecutor refer to the prior convictions in closing argument?
I do not recall. The prosecutor, the defense attorney brought out the fact that he had multiple prior convictions, that he had served 19 years in prison. The prosecutor followed up on that and detailed all the armed robbery convictions he had in his past, and that in and of itself was prejudicial. I don't recall offhand whether that was emphasized during closing argument. I think as far as determining the ultimate question in this case, whether the trial judge, whether his granting of the motion for relief from judgment was reasonable, I do not believe that there was clear error in any of his factual determinations. I don't think the prosecutor has really pointed to any clear error in his factual determinations. The prosecutor's main argument is that her belief that the witnesses lied.
Counsel,
but that's...
Counsel, you're impinging on your reserve time if you go any further.
Oh, okay.
Do you want to preserve that?
Thank you.
Okay, thank you.
Good morning, Mr. Chief Justice, Your Honors, and may it please the Court. I'm Margaret Gillis-Ayalp on behalf of the Wayne County Prosecutor's Office and the people of the state of Michigan. The people asked this Court to deny defendant's application because he has not shown that any alleged error by either trial or appellate counsel caused him actual prejudice. That is, there still would have been no reasonably likely chance of acquittal but for any of the alleged errors. The analysis of this case is fact-driven, and it must include the trial, which remains the main event here. And at trial, James Lemon, with no motive to lie, the evidence showed that he unequivocally and immediately identified defendant as one of the robbers to the responding officer. Lemon already knew defendant, and defendant testified he had been to Lemon's house before. In contrast, defendant sealed his own fate by telling an unbelievable story which made no sense, in claiming that Lemon identified him at the scene because defendant later would not tell him through Craig how to find Terry. The jury would have found this testimony nonsensical and still convicted defendant even without any of the alleged errors. In granting relief, the trial court committed multiple clear errors. It completely ignored the trial testimony and failed to make credibility determinations regarding the Ginther testimony when compared with the trial record. It made other clear errors as well. In short, the Court of Appeals got it right in finding the trial court abused its discretion in granting the MFRJ. And with that, I invite questions.
So when you say we should deny because, I mean, you said a couple different things. I just want to make sure I understand your position. We should deny because the defendant can't show actual prejudice from any of the errors. That's how you opened. Is that what you think?
Correct. That's our strongest argument, yes.
Okay. So we shouldn't, then you also said at the end the Court of Appeals was correct, but you've conceded that the Court of Appeals was not correct in holding that the defendant had already raised the issues that he raised in his motion, right?
Well, the Court of Appeals got the right result. We conceded.
Okay, fair enough. I get that. I said that was how you opened, and you agree that's your strongest argument. Do you see any value in us ruling against the defendant for the right reasons? Is there any value in a court getting to the right answer the right way?
Well, again, Your Honor, I would submit that the Court of Appeals reversed the trial court for the right reasons. The MRE 609 claim had not been considered before, so the Court of Appeals on that basis was wrong. But it also still considered the MRE 609 issue by looking at what the Hewitt-El court found, that the testimony of the victim was compelling, defendant's testimony was nonsensical, so there was no possible prejudice. But I do not see any value in this court taking this case. I do think our statement of facts alone sets forth why that is the case. The alibi story is clearly bogus. I can go into that if the court prefers.
I was asking you kind of a hypothetical question. I was asking, do you think, just assume, I'm not saying this, I haven't talked to any of my colleagues, they might all think you lose. Assume we all think you win on prejudice. Just say everyone agrees. This is all hypothetical. I'm just trying to understand. We haven't discussed it. Assume we all think you win on prejudice. Is there no value in us like saying why you win for the right reason? Is there no reason? Is there no value in courts getting things right?
Well, I think at most I would deny we would request that the court deny the application. At most, if this court is so troubled by Hewitt-El's analytical errors, I don't think the whole opinion was wrong. And certainly not, obviously, and the result was right. If at most this court could remand to the Court of Appeals, we're not asking the court to do this, but I do not see any value in this court being an error-correcting court. I don't see any value in the jurisprudential significance of this case to other cases. The Court of Appeals got it right. I mean, if this court were going to correct Court of Appeals all the time, the analyses are not always right on, but the results are right. Pertaining to...
Can I ask you, counsel, about the 5 prior convictions? I mean, I look at the standard under 609, and I have a hard time understanding what conceivable strategic reason there could be for permitting evidence of 5 prior convictions, especially when most, if not all of those, referred to something with which defendant himself had been charged. And I guess it's hard to think of something that's more damning, more prejudicial than, prior convictions introduced that go to exactly the same offense with which the defendant has been charged. Why aren't you more troubled, or why shouldn't this court be more troubled by that error alone?
Okay, the people are troubled. We're not troubled, but we do concede that it was not prudent for trial counsel. I agree with Your Honor. There was no strategic reason to do that. I think he was a little bit blindsided. I think the record suggests that he thought maybe there were 2. He didn't ask specifically what was their nature. And then on cross-exam, the prosecutor elicited that there were 5 and that they were armed robberies. But let's assume error there. That doesn't get the second prong of Strickland met, because there has to be a reasonable probability, but for that error, the result of the proceeding would have been different. And here that simply cannot be the case. We've got defendant's unbelievable testimony. If armed robberies...
You call it concocted nonsense, right?
I did, yes.
But that's usually a decision for the trial court, the fact finder at trial, and not this court.
Well, yes, Your Honor. And I would note that the trial court has done a 180 on its fact findings, not in front of the jury, the fact findings, but the fact findings it made at the motion to substitute counsel. It's done a 180. It found defendant had not at all helped his counsel with the alibi witnesses, and when the so it did not find defendant's story very worthy of further investigation and worthy of substitute counsel. But getting back to MRE 609, armed robberies have been deemed by Michigan courts to be probative of veracity. They are theft crimes. If one armed robbery is probative of veracity, 5 armed robberies are even more probative of veracity. It has to go up commensurately.
So they're automatically admissible? Is that your
No,
position?
not at all, Your Honor.
So why were they admissible in this case?
Well, there was no ruling that they were.
I understand that, but we were talking about whether the failure to object is prejudicial. I think we all agree it's ineffective, although apparently you don't because you think they go to veracity. And I'm just wondering why you think that.
Why? Because People v. Allen and People v. Minor have held that armed robberies are probative of veracity because they're theft crimes.
I think it's the point that they could be. They're not automatically admissible like...
Our position is not that they are automatically admissible, not at all. There's a balancing test to weigh probative versus prejudicial. We recognize that. We're saying...
But what is it about these prior offenses that go to the defendant's veracity in this case? Isn't that the question the trial judge would have asked if the objection had been raised?
Oh, I can't imagine what the trial court would have asked. He may have, and I think it's probably given this trial court and his statements in his MFRJ opinion that he may have excluded most, if not all of them. But
you could imagine what he would have asked if you imagine that he would have looked at the rule of evidence, right? 609.
Right.
It tells the judge what
Yeah.
to ask, doesn't it? And what to think about and what to consider. It's very helpful in that way.
absolutely. So he would have, let's assume Judge Morrow would have excluded all 5 prior armed robberies. That gets us to prong 1, that there was error. It doesn't get us to prong 2. There has to be a reasonable probability that the result of the proceeding would have been different.
Your position is that the other evidence was so airtight that despite the fact that this was error to admit specifically because its prejudicial effect far outweighed its probative value, and there's really no indication and no argument made that it has any bearing on his credibility, I think your argument is that the other evidence is so airtight that it wouldn't matter, that the jury knew that he had 5 prior armed robbery convictions when they were thinking about whether to convict him for armed robbery.
Right. I'm not arguing with Your Honor that there is a problem that he didn't move to have them excluded. I don't know how Judge Morrow would have ruled. Let's assume he would have excluded all of them. But when Your Honor says I don't know you're not sure how they're probative of veracity, they have been deemed probative by Michigan courts.
Well, on an individual basis, based on the facts of those cases, your office could have made an argument that this armed robbery, because of something that specific to it, that has a bearing on the charges in this case, right? You have to make a very specific argument. None of that was made here. That's all I'm saying. So, yeah, I agree with you. Theoretically, under this rule, it's possible for an armed robbery conviction to come in.
Right.
But based on everything we've been told so far, it doesn't seem like anyone thinks these armed robberies would have come in this case. And I think you're agreeing with that, although you seem to go back and forth on that point.
I don't intend to vacillate on that. Probably they would not have come in here. Our position is that defendant sealed his own fate, as I mentioned earlier. He told an unbelievable story which made no sense. I can point to the transcript pages. He stated that Lemon identified him at the scene because later defendant would not tell him how to find the shooter through Craig. It's just not plausible for a reasonable jury to believe that this shooting victim with a stomach gunshot wound, slumped over, would have, in the few minutes it took for the police to arrive, come up with this, you know what, I'm going to get back at Jonathan Hewitt because he introduced me to Terry. And I already know he's not going to tell me how to find him. It's just not conceivable. That did him in. Certainly, cases can be won, as this one, the jury found guilt beyond a reasonable doubt on one very credible witness, buttressed by Officer Treese, testifying that, yep, he identified him immediately at the scene, gave me his first name and his phone number. At the hospital, defendant identified him again. And again, at the photo array, he identified him again. This is a person he knew already. He was honest about his alcohol and drug abuse, that they were there to get high and drunk that day. He was a credible witness. That matters in this assessment of the actual prejudice of the MRE 609 issue. And regarding the clear errors of the trial court, one we want to particularly point out is that the trial court, in its MFRJ opinion, made no finding of good cause for defendant's failure to raise McCline or Leon as an alibi witness or the two medical witnesses. So the court skipped that step. It found good cause for failure to raise the 609 issue because it found Daniel Rust ineffective on appeal. It made no finding as to Rust on the medical witnesses or McCline or Leon. And then it jumped ahead and made conclusory actual prejudice findings. At one point it even said absolute prejudice. It didn't delve into at all comparing the credibility of the Ginther alibi witnesses with the trial testimony. The trial court and defendant have completely ignored the trial testimony. It's kind of astounding. As if that didn't happen, as if it wasn't the main event. It was, and it has to be under this court's jurisprudence. If there's a rule, if this court chooses to take the case, the rule should be that the defendant cannot prevail on an MFRJ motion where he would not have prevailed on direct appeal. It simply cannot happen that way, and the rule is not intended for it to be that way. He has to meet all the same burdens of proof he would on direct appeal. Trial court completely ignored the trial testimony. In doing so, if it had done so, it would have found that the story simply did not add up. One says he saw her, one says she saw him, and most glaringly erroneous was even the mention of Sheila Jackson's name. She did not testify once in this proceeding. She did not show up once. We haven't met her. We have one affidavit that's not notarized that maybe gets you in the door for a Ginther hearing, but once there, she's not called, and the trial court, in its opinion, is citing to her, quote, testimony. There are glaring errors. I can go on and on if the court would like. The trial court simply reached the result it wanted to reach without applying the facts to the law, and therefore its conclusions were erroneous as a matter of law, and that in and of itself is an abuse of discretion. Thank you.
Thank you, counsel. Ms. Grove, you have 3 minutes.
Well, just briefly, as regards the prior convictions being introduced against Mr. Hewitt without any kind of motion to suppress, the court did find it was absolutely prejudicial. I think this is borne out by the trial or the Court of Appeals opinion cited in the brief that when the jury hears that the defendant did it before, they naturally assume, well, he probably did it this time. And in this case, they heard that he did it before some 5 times. And there was there's absolutely no effort to protect the defendant from that prejudice. As far as the defense attorney failing to bring in the alibi witnesses, the defense counsel has a duty to investigate, and this attorney did nothing at all. He talked to Sheila Jackson once. He didn't do any kind of Google search to get an address. He left it up to the defendant, who was incarcerated and whose phone calls were limited. Mr. Hewitt-El, as I said, he was not representing himself. He had an attorney. His attorney did nothing as far as a pretrial investigation. As the court found, part of this was probably due to the fact that he wasn't being paid. He was waiting around for the family to find some other attorney. He wasn't doing his job investigating. And again, this was really the only substantial defense he had besides the medical testimony, which the trial counsel did nothing to bring those witnesses in either. It's only the prosecutor's opinion that the trial court ignored the trial testimony. The judge was well aware of the testimony at trial. There was only one witness at trial. As I've argued, there was nothing to corroborate his testimony. And the court's reasoning, the court's findings are to be afforded great deference. And I don't think this court can find that the judge erred by finding that Mr. Hewitt was denied a substantial defense, in fact, 2 substantial defenses, that he was severely prejudiced by counsel's failure to move to suppress his convictions, and that the jury is entitled to evaluate the credibility of his alibi, and that he is entitled to a new trial.
I think your
Are
time
there
is
any
up, Counsel.
more questions? And I would just ask the court to give great deference to the trial judge, deference which he deserves, and that his findings are not an abuse of discretion. Are there any other questions?
Thank you, Counsel.
Thank you.
Thank you. The case will be submitted.